welcome to the Legal Friday edition of The Bullet. Today, Paul is joined by Alex Ooley. Alex is an attorney in Southern Indiana and hosts the Forge of Freedom podcast.
Although Alex is an attorney, nothing said on the show today should be interpreted as legal advice. If you need legal advice, seek out a practicing attorney in your area.
As always, we encourage your participation in the show. If you comment on the live video, your comment may make it on the air.
Hey everyone, welcome to another edition of The Bullet. This is the Legal Friday edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, as you heard in the intro, Alex Ooley from the Forge of Freedom podcast. Alex, thanks for coming along today, man.
Yeah, great to be with you, Paul. And I like your new intro. It's almost like a starting lineup for a basketball game or something, but it's got a Top Gun feel to it. So
yeah,
I like that.
Up first, playing center, Maverick. Anyway, we do have a lot to talk about, and as again it said in the intro, if you want to comment on the live video, we get most of those comments right away. Comment, and we'll get your comment on the air. We'll talk about it, but. The big legal news, really of the last 2 weeks, but certainly of this week, Alex, is a case out of Massachusetts. I'm going to go ahead and play the story here, and then we'll talk about it.
Individual only loses a constitutional right if he commits an offense or has been engaged in certain behavior that is covered by 18 U.S.C. Section 922. Judge Coffey wrote on August 3rd in Commonwealth of Massachusetts v. Dean F. Donnell. He doesn't lose that right simply by traveling into an adjoining state whose statute mandates that residents of that state obtain a license prior to exercising their constitutional right. To hold otherwise would inexplicably treat Second Amendment rights differently than other individually held rights. Therefore, the court finds that GL 269, Section 10A, is unconstitutional as applied to this particularly situated defendant and allows the motion to dismiss on that ground. The ruling could have significant implications for determining the scope of the right to carry a firearm in public. It is one of the first legal decisions to address gun carry rights across state lines since the Supreme Court recognized a general public carry right in New York State Rifle and Pistol Association v. Bruin last June. It could fuel gun rights advocates' push for the right to travel in all 50 states with firearms in public, also known as national reciprocity. The defendant in the case, Dean Donnell, is a legal resident of New Hampshire. New Hampshire is a permitless gun carry state, meaning anyone 18 years of age or older who can legally possess a firearm may carry it in public openly or concealed. It also issues carry permits to residents for reciprocity purposes. However, Massachusetts does not honor New Hampshire permits. Judge Coffey's order does not specify whether or not Donnell had a valid New Hampshire permit, only that he was in compliance with his home state's laws on the possession of the firearm when Massachusetts charged him. The law under which he was charged, GL 269, Section 10A, creates a mandatory minimum sentence of 18 months in prison for anyone convicted of possessing a firearm in public without a license. Judge Coffey wrote that Donnell's conduct was clearly covered by the Second Amendment. Therefore, under the standard of review set in Bruin, he said the government of Massachusetts needed to show a historical tradition relating to disparate treatment of non-residents to uphold the law.
Alex, this is encouraging, but my opinion is it does not mean we have national reciprocity yet.
That's exactly right. I like the logic in the opinion. I enjoyed reading it, but this opinion has no binding authority on any other court. This was a decision out of the Massachusetts State Court. It was the Lowell District Court, which is the trial level court in Massachusetts. So this opinion is not even binding on other courts in Massachusetts. It doesn't even have persuasive authority. It really has no authority at all except over the parties in this case. So, but with that said, I think it's good news. I think that the logic in the opinion is excellent, and I hope that the other judges around the country take notice of this opinion and the reasoning in it, because the defendant here, charged with a crime in Massachusetts for simply crossing state lines, and the judge correctly points out that you can think of no other constitutional right or individual right where that you lose simply by crossing state lines. In the Supreme Court, I think there are flaws with incorporation doctrine. One can quibble about incorporation where the Bill of Rights has been selectively applied to state government action, not just federal government action. But the Second Amendment, as we know from the McDonald case, which the Second Amendment Foundation was involved in and litigated, the Second Amendment has been incorporated to apply to state government action, and therefore the states cannot violate the rights protected by the Second Amendment. And I think that this licensing requirement in Massachusetts, I think licensing requirements everywhere, frankly, violate the Second Amendment. Unfortunately, I believe it was the Kavanaugh concurrence in Bruin, explicitly stated that the Bruin decision does not impact shall issue licensing schemes, and I suspect that Kavanaugh would uphold shall issue licensing. But in my view, any license to exercise a right turns a right into a privilege, and that's exactly contrary to what the Founding Fathers intended.
My opinion lately, and this does not change that. Matter of fact, I think it strengthens it a little bit, is that the way we're going to get national reciprocity is not through legislation. It's going to be through the court system when it comes, and I say when, not if. But that we're still looking at years, if not decades, off for that. Would you agree with that?
I agree, but that's why the next election is so important. A lot of people are thinking about the upcoming election with the debates going on this week and Donald Trump interview with Tucker Carlson. But remember, the Supreme Court didn't accept a Second Amendment case for review for over 10 years between the McDonald case and the Bruin case. And they didn't accept a Second Amendment case because they didn't have the support for a Second Amendment case on the court. The composition of the court wasn't such that it was friendly to a Second Amendment outcome, or at least an outcome that protected the Second Amendment. So luckily, with Donald Trump as president, we got Gorsuch and Amy Coney Barrett, which tipped the balance in favor of individual liberty and the right to keep and bear arms. But we could lose that. I mean, we have some justices on the court that are getting up there in age. Thomas is a great justice for the right to keep and bear arms. He's getting up there in age. And frankly, a lot of these cases that are going on around the country, whether it's with respect to the age requirements for purchasing a firearm, or whether you can possess a so-called assault weapon, i.e. a normal semi-automatic rifle, these cases are being prolonged, I think, by the anti-gun crowd, with the hope that the composition of the court changes and they can get these sorts of tyrannical anti-gun laws upheld. So I think that people need to stay engaged, and at the state level and at the federal level, call your politicians, get involved with groups like the Second Amendment Foundation so that we can maintain a majority on the Supreme Court, because that's going to be a significant factor in protecting our rights going into the future.
I was just, you brought that up, but it's some quick Google foo, and ages of current Supreme Court justices: Clarence Thomas is 74, Samuel Alito is 72, and Sonia Sotomayor is 68. So it would not be for the Second Amendment, it would not be a bad thing if Sotomayor were to retire or leave her seat for the Supreme Court. But Thomas and Alito would be devastating if a Democrat got to replace them on the Supreme Court.
Yeah, exactly. Because remember, Heller and McDonald were 5-4 decisions. Bruin was a 6-3 decision. and it would only take a small change in the composition of the court to change the dynamic of the Supreme Court, because frankly, Kavanaugh and Roberts are not great on the Second Amendment. They were in the majority in the Bruen case, but they wrote a lot of dicta in that case that I think is inconsistent with the text, history, and tradition test that was outlined in Bruen, and I think we would get much weaker opinions in favor of the Second Amendment going forward if they were the leadership in the court with respect to that issue.
Absolutely. Let's get comment in here quick. Robert says, I think the biggest benefit of the decision, is, speaking of the Massachusetts decision, is going to be that each time the issue comes up, defense attorneys are going to cite the case and the court will have to address it over and over. Would you agree with Robert, Alex?
I think that defense attorneys in Massachusetts will cite it. Defense attorneys in other states could cite it, but it has no binding effect. The court can read it or dismiss it entirely because the court has no obligation to consider it, simply because it's a trial court opinion from Massachusetts. And for an opinion to have binding authority, it has to be either an intermediate appellate court or a Supreme Court at the state level or federal level.
So intermediate federal court, that would mean like the Fifth Circuit would have to decide en banc, or not just a single judge out of the Fifth Circuit. It would have to get appealed up to the Fifth Circuit Court of Appeals, and they'd either have to take it on as a 3-judge panel or the entire Fifth Circuit or any of the other circuits, right?
Right, or just with this example in Massachusetts, the Massachusetts Court of Appeals. If the Massachusetts Court of Appeals upheld the trial court's decision, then the Massachusetts Court of Appeals opinion would have binding authority on the trial courts in Massachusetts, the inferior courts, so all the courts below it. But because the trial court in Massachusetts has no courts below it, it's either equal in power or below or beneath in power all other courts. It has no binding effect.
Okay. Let's go ahead and go on to our second story here. Our second story out of Colorado, and we'll get this one off. This is out the Colorado Sun.
A new Colorado law raising the age to purchase all firearms in the state to 21 could be blocked for weeks, months, or possibly even years after a federal judge Friday declined a request from Governor Jared Polis to let the measure take effect. Chief U.S. District Court Judge Philip A. Brimmer earlier this month temporarily barred the state from enforcing Senate Bill 169, which was passed by Democrats in the legislature this year and signed into law by Polis, who is also a Democrat. In blocking the law through a preliminary injunction, Brimmer found that Rocky Mountain Gun Owners, a hardline gun rights group based in Colorado, was likely to succeed in its lawsuit seeking to invalidate the law on Second Amendment grounds.
Good news out of Colorado. I'm not the biggest fan of Rocky Mountain Gun Owners or the National Association of Gun Rights, their parent organization, but as I've said before, even a blind squirrel finds a nut every once in a while. This comes straight, another one, Alex, comes straight out of the Bruen decision, where Bruen says text history and tradition. There's no text history or tradition of certain people under a certain age getting rights and certain other people not getting different rights.
Right. Great point. And I think the text history and tradition obviously does not support this sort of ban on the possession or purchase of firearms by individuals between the ages of 18 and 20. The people between the ages of 18 and 20 are clearly contemplated within the meaning of the people in the Second Amendment. As we all know, the Second Amendment says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And that clearly includes 18 to 20-year-olds. A common argument being made by the anti-gun side with respect to supporting these restrictions is that 18 to 20-year-olds commit more crime than most of the adult population. And I would point people to John Lott's work in this regard because he talks about this a lot. And it's true that 18 to 20-year-olds generally commit more crimes than other age group adults. But the 18 to 20-year-olds who are eligible to purchase a firearm and would pass a background check are not more likely to commit crimes. In fact, they are extremely law-abiding. So it is only the sort of people who would otherwise commit crimes or who would not even pass a background check to purchase a firearm that would be more likely to commit crimes. So I think that these laws are completely misguided and unsupported by the data as shown by John Lott. And if I can find that link, I'll share that in the comments on Facebook and YouTube. But if you just search John Lott's crimeresearch.org, his website, he has many articles and discussions about this topic.
I'm reminded, I just today caught your latest episode of The Forge of Freedom. I rarely get them on the day you release them, but I watched it today as I was getting ready for the show. And you brought up a point on that episode that I think is equally applicable here. You stated in your most recent episode that that police are more law-abiding than the general population. And people who have concealed carry permits are even more law-abiding than police are as a group. That's if you're willing to go get a concealed carry permit, there's no reason at all that there should be any restrictions on anything you could buy as far as firearms, my opinion.
Right, and frankly, even in states where there is permitless carry, most people are still obtaining permits because they're helpful for reciprocity. But you're exactly right. The John Lott, and there have been other people who have confirmed this data, found that police officers are more law-abiding than the general public. It's by something like 8 times. And then people who have a license to carry a firearm are something like 8 to 10 times more law-abiding than the police. So that just serves to demonstrate that these laws proposed by gun control groups will only serve to restrict law-abiding citizens and not the criminal. Criminals will obtain guns no matter what. I mean, think about, I bring up drugs quite a bit because I deal with drugs in my day-to-day job representing criminal defendants. Drugs, I can't tell you how many clients I've had say that drugs are easier to get in prison than they are in the streets. If people want something, they will get it. If you can't keep drugs out of a controlled population in prison, how are you going to keep guns off the streets and out of the hands of criminals? It's a fool's errand, and all these gun control laws do is keep guns out of the hands of perfectly law-abiding citizens.
Yeah, who should be the people that have them.
Right.
Let's get a couple of comments in here. I'm going to actually get a series of comments from Warsaw Patriot in. Historical text and tradition, the only time there was regulations in 1791 of states was in saloons and businesses and some towns and some cities. Even back in the 1800s, go to the next one. In saloons, some require you to leave your firearms outside the building, and when you leave, you can pick them up. They even put them in bars and wood boxes. And one more here. And the towns are operated by town marshals and sheriffs. I can't imagine going to check my gun by just putting it in a wood box outside of a business. That would be a bad precedent for now, but
the closest corollary to that today that I'm aware of is that, at least in Indiana, casinos are required to keep a secure area to lock up your firearm because you can't have a firearm on a riverboat casino in Indiana. So they have a secure storage facility where you can turn in your firearm before entering the casino. So that would be it's kind of strange, but it's the closest corollary to that example. But this brings up a good point related to the age restriction discussion. We know from the time of the founding, not only does the text, history, and tradition not support these types of gun control regulations, it is exactly the contrary. 18 to 25-year-olds were required to keep arms in their home for defense in case they were required to, or called to serve in the militia. So not only were they allowed to, they were required to in some circumstances.
Well, and I would say that even younger than down to 16 in many cases, there are a lot of examples of 16 and 17-year-olds fighting in the Revolutionary and going forward to the point where a lot of people who would like gun control to draw their examples of text, history, and tradition from going forward to the time of the Civil War. 16 and 17-year-olds were still fighting in the Civil War, and they brought their own firearms. It wasn't until really the World War I that firearms were supplied to people that were fighting in the war. Prior to that, you brought your own.
Yeah, exactly. So not only is there an absence of history to support gun regulation, there's history to contradict it completely.
Absolutely. I want to get to our next story here. This one is in the not so great news category. This one off of ammoland.com. It's about Connecticut.
Individual only loses a constitutional right if he commits
Whoops. Did I hit the wrong one? I think I did.
Yeah.
That showed good. Let me try this one.
On August 3rd, 2023, Judge Janet Bond Arterton of the United States District Court for the District of Connecticut ruled on whether the recent Connecticut law banning the possession of common semi-automatic rifles and pistols under the appellation of assault weapons and of standard capacity magazines which hold more than 10 rounds. Judge Arterton ruled the law is not prohibited by the Second Amendment. She does not see it as an infringement because, she claims, assault weapons and magazines over 10 rounds are not arms protected by the Second Amendment. Magazines that hold more than 10 rounds are referred to as large capacity magazines or LCMS by the court. From NAGR v. Lamont. For the reasons discussed below, the court denies plaintiffs' motion for a preliminary injunction because they have failed to meet their burden to demonstrate a likelihood of success on their claim that the challenged statutes unconstitutionally burdened their Second Amendment right to keep and bear arms. Plaintiffs' proposed ownership of assault weapons and LCMs is not protected by the Second Amendment because they have not demonstrated that the specific assault weapons and LCMs in the challenged statutes are commonly sought out, purchased, and used for self-defense. Although this failure alone would have been fatal to plaintiffs' claim, defendants have submitted persuasive evidence that assault weapons and LCMs are more often sought out for their militaristic characteristics than for self-defense, that these characteristics make the weapons disproportionately dangerous to the public based on their increased capacity for lethality, and that assault weapons and LCMs are more often used in crimes and mass shootings than in self-defense.
All right, I'll get to that comment in just a second. I just looked over and see the comment that kind of made me giggle a little bit. But Alex, this we're putting we're going back to the two-step process again. Something denied in Bruin, the two-step test, I guess, is what I was trying to say. This judge seems to say that these are weapons not for defense, but these are weapons for crime and for military. And so therefore, I can rule this way. Well, Bruin said that a balancing test, a two-step balancing test, is one step too many, I believe, was exactly what Thomas wrote. What's your thoughts here, man?
So the two-step test that you're referring to is what's called the tiers of scrutiny analysis. And the tiers of scrutiny analysis refers to a process where the court says, okay, is there a right that's being infringed or burdened? And then if so, is there a government interest in regulating or infringing upon that right? And the court, as you said that second step, whether there's some government interest in restricting that right, is one step too many, because that balance between the individual right and the government interest was done at the time that the Bill of Rights was adopted. When the Second Amendment was ratified, that balancing test had already been completed, and there is no further balancing required. So that's the test that you're referring to, and that's essentially what the court is doing here. You're exactly right. And the other thing that the court is engaging in here is what we talked about earlier, where courts and gun control litigants are trying to litigate these issues and drag them out, prolong these issues over a significant period of time, hoping that the court's composition will change. And one way that they do that is by manipulating the tests that have been established by the Supreme Court, including the common use test, which is what the court is doing here. The common use test, as we know, just says that those arms that are in common use, that are lawfully possessed and used for lawful purposes, are protected by the Second Amendment. And here the court says, well, if it's not actually used for self-defense, then it's not protected. Well, that's not the standard. Is it commonly possessed or used for lawful purposes? It doesn't have to be self-defense, it could be sporting purposes, it could be other purposes, but it's not actually used, it's possessed for self-defense. And frankly, that's what most people do. They rarely have to use the arm in self-defense, most people anyway, but we know there are millions of defensive gun uses every year, even where those guns are not actually fired. So her assertion that they're used more for crime than for actual self-defense, I think, is also untrue. So there are lots of problems, a litany of problems here with her analysis, and as you say, it engages in one step too many in terms of her analysis.
I'm just going to leave it at multiple. I'm going to say more than one, and I'm going to leave it at that. AR-15 rifles in the Lathrop household. And I'm going to say both of them are used for self-defense because they are staged and ready for use should the need arise. Use doesn't need to be that I fire them in self-defense. I believe use can be they are ready for self-defense. So I think this judge is totally missing the mark on the use of the AR-15 for self-defense.
Well, and we know that your intention is true, Paul, not only from Heller and from Bruin, where they affirmed the common use test, but also from Caetano, which was a case that didn't relate to firearms at all. It related to a different type of arm, a stun gun, and stun guns are rarely used, actually used in self-defense, and there are somewhere around 200,000 in possession of individuals around the country, which is far fewer than AR-15s. AR-15s are the most commonly possessed rifle in the United States. There are more AR-15s than there are F-150s on the road today, which is the most popular truck in America. So clearly, if any arm, firearm or otherwise, is included in the common use test, the AR-15 would be one of those.
Let me get I'm going to go to a couple of comments here. First up, Robert. Paul, John Connor does not approve of your collaboration with AI. He probably wouldn't. I want to get this one from Charlie in. Charlie Chambers asks, and I think we covered part of this earlier. I think Charlie's a little late to the game today. What has been the impact of the Bruin decision? What has the impact of the Bruin decision been recently? And we just discussed earlier in the show the decision out of Massachusetts. Any others come to mind, Alex?
Well, we have one in the show notes that we didn't discuss about the red flag laws. I think that text history and tradition does not support these red flag laws that have been implemented nationwide. I think that Bruin the analysis, if it's applied faithfully, would strike down these red flag laws, because let's be honest, the red flag laws, no matter how much due process is built in, that due process is after you're deprived of your property and your liberty. And that's simply opposed to the Constitution. There's due process twice in the Bill of Rights, in the Fifth Amendment and the 14th Amendment. And in red flag laws, you are deprived of your firearm, and then you're afforded a hearing and process later. And that's exactly the reverse of what the Constitution explicitly says, and I think contrary to the text, history, and tradition of the Constitution. I'm also hopeful that we're still waiting for the decision in the Mock versus Garland case out of the Fifth Circuit, but I think we're going to get some good news out of that court soon, and of course that will rely heavily, it'll rely partly on the Administrative Procedures Act, but I think that Bruin will ultimately have a huge impact in that case as well.
If you got time, Alex, we're already late, but I do want to get that last story in. Have you got time to hang out with us for a little while longer?
Sure.
All right. I'm going to go ahead and bring up, I think it's this one. I hope it's this one. Here we go.
August 3rd, 2020.
Nope, it's not that one.
The Second Amendment Foundation has announced the launch of a project aimed at challenging so-called red flag laws, which have raised alarms among gun rights advocates over concerns about due process. SAF is calling this initiative Capture the Flag, and the organization, which has become a legal powerhouse in firearms rights litigation, is initially focusing attention on laws in 6 states: California, Florida, Maryland, Massachusetts, New Jersey, and Washington. They are among 21 states and the District of Columbia where such laws, called Extreme Risk Protection Orders, ERPO, have been adopted. The announcement came 48 hours after SAF filed what may be the first of several federal lawsuits challenging such laws. Earlier in the week, the foundation and one of its members, Donald S. Wiley, a 64-year-old Marine Corps veteran, filed a federal lawsuit challenging the Maryland law, which was adopted 5 years ago. That complaint was filed in U.S. District Court for the District of Maryland, Northern Division. Named as defendants are Maryland Attorney General Anthony G. Brown, Dorchester County Planning and Zoning Director Susan E. Webb, and Dorchester County Sheriff James W. Phillips. All 3 are sued in their official capacities, and Webb is also being sued personally.
On this one, SAF, this is a major push from SAF, and I expect to see a lot coming out of this one. It's not quite that. Let me step back just a hair. There are right now 26 states as of about 2 weeks from now. There are 26 states that have permitless carry, and there are 21 states, some of them the same states, but not a lot, that have extreme risk protection orders or red flag laws. I expect this to be getting a lot of legal work from SAF, and I think we're going to be making a lot of gains going forward on this one. Almost half the states have extreme risk protection orders. I hope that doesn't expand in the near future. I hope, matter of fact, they get knocked down in the near future. Glad to see this from SAF. What do you think, Alex?
No, I'm glad as well, and unfortunately, I'm sad to say Indiana is one of those states that is both permitless carry, which is awesome, but also has a red flag law or an extreme risk protection order law. And the fundamental flaw with these, as Adam Kraut says in the article, he said the fundamental flaw in all of these laws is that they consider people guilty until they prove themselves innocent. And that's the essence of what's going on with this. But I also like this quote from Alan Gottlieb further down in the article. He says, all of these laws should raise alarms because they prioritize citizen disarmament ahead of due process. And that can easily lead to deprivation of rights under color of law. And this exactly emphasizes the point I was making earlier, that it deprives the person of their life, liberty, or property, and then provides due process. And that's not the way that our Constitution is structured.
Amen. Well, we are way long now. So, Alex, as we go out, it was mentioned in the intro to the show, but I'd like you, if you would, plug the Forge of Freedom and anything else you want to talk about today, man.
Yeah, so I started the Forge of Freedom earlier this year. We've got 54 episodes as of this evening, and we release a firearms-related episode every Monday for Monday Gun Day. I usually do those with my father. But related to a topic we were discussing earlier, I also interviewed Stephen Hallbrook about his book, America's Rifle, the Case for the AR-15. So if you have any interest in that, you might check out that interview as well as his book. It's an excellent defense and argument for the AR-15. His legal analysis, his philosophical analysis, and his historical analysis are second to none in that book. So if you're interested, check out the podcast and also check out Stephen Hallbrook's book. I would note, too, that I think it's the 49th anniversary of the Second Amendment Foundation. Is that right, Paul? Is that today?
Exactly right. We're going into the SAF is going into its 50th year this year.
Yeah, and I think that the Second Amendment Foundation is just catching its stride. I mean, obviously they were instrumental in McDonald, but they're doing great work, especially in the aftermath of ruin. They are seizing the moment to advance our individual liberty, and I obviously would encourage people to continue to support them and support them in whatever way you can, because with these, just by example, with these red flag laws, Second Amendment Foundation is leading the charge against those deprivations of individual liberty. So I would certainly encourage people to support the Second Amendment Foundation, and so that they can continue to fight for our rights for another 49 years.
Amen. Amen. I don't think I'll be around in 49 years to be helping with it, but God willing. Want to get this comment in here real quick. Thanks, Paul and Alex. Started listening to The Forge of Freedom from episode 1. Great series. That from Robert.
Thanks, Robert.
Yeah, absolutely. And if you're not listening to Forge of Freedom, you need to. It's on all the podcast apps. I catch it on YouTube. As I said earlier, I caught it today as I was preparing for the show today. You really need to be looking at that or listening to it every time it comes out. Alex, thanks again. And everybody, do come join me tomorrow night. We have, as soon as I get my calendar pulled up, we have tomorrow night for the weekend edition of The Bullet, Tom Walls of the Firearms Academy of Seattle, Mike Piwowarski, and Tony Simon again will be joining us tomorrow night to go over the weekend review for Second Amendment news. That is going to do it for us today. Thank you, everybody, for watching. Podcast listeners, thanks for listening, and we will see you next time.